I sent the SEC one email. One. And 4 days later, a lawyer I had never met called me to say that $427,000 was being held in my name, pending the outcome of an investigation that I had quietly set into motion from the guest bathroom of my father-in-law's estate while my unborn daughter pressed her heel into my ribs like she was trying to remind me to breathe. Some people who know this story think I went too far. A few of them are still in my life. I want to hear what you think by the time I'm done. Hello, everyone. Thank you for being here with me today. Tell me in the comments where you are watching from. I have heard from people on 6 continents now, and it still makes me stop and think. My name is Vivienne Caro Bastian. I am 38 years old. I'm a corporate finance attorney by training, though I stopped practicing full-time when my daughter was born, and I'm telling you this story today because for a long time I thought it was too complicated to explain. Too many layers, too many players, too many moments where I looked weak and was actually loading the next round. But someone told me recently that the complicated ones are the ones worth telling. So here we are. To understand what happened in that house on the night my father-in-law told me to pack my things, 8 months pregnant, on a Tuesday in November, in the middle of a dinner I had cooked, you have to understand who he was, who they all were, and who I was in that family and why they were so completely certain that I would simply go. Take me back about 4 years and 3 months to be exact. My name before I married was Vivienne Osei Caro. I kept Caro when I took Bastian because my mother's family name is Caro and there are only 4 of us left who carry it, and I am sentimental about certain things. My husband's name is Elliot Bastian. We met at a conference in Atlanta in the spring of 2020, which I know sounds like a terrible time to meet anyone, but there we were, both in the hotel bar on the second evening because neither of us wanted to eat alone in our rooms, and we talked until 2 in the morning about pension fund litigation and a television show we had both been watching and whether or not regional accents were disappearing. He was funny in a dry, quiet way. He noticed things. He asked follow-up questions. I thought, this is a person who listens. I was not wrong about that. Elliot listens. It is nearly everything else about his family that I misjudged. I was 34 when we married. I had been working for 6 years as in-house counsel at a mid-sized investment firm headquartered in Charlotte. I was earning well. I had my own apartment, a savings account that would have surprised most people who knew me, and a professional reputation I had built from nothing. I was the daughter of a Ghanaian immigrant father and a third-generation South Carolinian mother, and I had clerked and worked and studied my way into every room I sat in. I was not handed anything. I want to be clear about that because it matters to what comes next. The Bastian family is old Carolina money, not flashy. They did not drive expensive cars or vacation loudly. What they had was property, a lot of it, and a family business that had been operating for 3 generations in commercial real estate development. Elliot's father, Roland Bastian, had taken the company from his own father and grown it substantially. By the time I came into the picture, Bastian Development held somewhere around $40 million in assets, though the number that appeared in their annual filings was closer to 28 million, and I want you to hold that discrepancy in your mind because we are coming back to it. Roland's wife, Elliot's mother, is named Constance Bastian. She's 64 years old, was a debutante, still has the posture of one, and operates on a system of polite condescension so refined it took me almost a year to recognize it for what it was. She never said a cruel thing to me directly. What she said was things like, "Vivienne, you are so practical," in a tone that made practical sound like a minor defect. Or, "I do think it is wonderful when women are career-focused," delivered to me across a dinner table while she patted Elliot's hand and smiled at him in a way that suggested she found his choice of wife confusing but had decided to be gracious about it. Roland was less subtle. Roland Bastian is 67 years old. He has the kind of face that has always looked authoritative, square jaw, silver hair kept short, the permanent expression of a man who expects to be the last one speaking in any room. He built his identity on the company and the family name in equal measure, and he had very specific ideas about how both should function. Elliot was the oldest son and the presumed heir. Elliot's younger brother, Devlin Bastian, was 31, had a business degree from Clemson, and had been working in the company since he graduated. Roland made no secret of the fact that he considered Devlin the more reliable of his 2 sons. Elliot had taken a detour into law and then into consulting, which Roland tolerated without ever fully forgiving. I was an additional variable Roland had not planned for. I noticed in the first few months of being part of the family that Roland never asked me about my work. He would ask Elliot about his projects. He would ask Devlin about the Greenville development. He would ask Constance about the renovations on their vacation property in Highlands. He would ask me what I thought about the meal or whether I had tried the wine before this. One evening at their home, a large, beautifully maintained house in a suburb of Charlotte that had been in the family for 30 years, I mentioned, just in passing, that I had recently completed a negotiation that restructured a debt portfolio worth approximately $90 million. I said it because it was relevant. We had been talking about interest rates and their effect on development financing. Roland looked at me for a moment. Then he said, and turned to ask Devlin whether he had looked at the contractors for the Henderson Street project. The table moved on. Elliot caught my eye from across the table with a look that was half apology and half helplessness, and I made a note in the part of my brain where I keep things I am not ready to act on yet. Constance, for her part, handled my professional existence by redirecting conversations toward the domestic. Had I thought about where Elliot and I would live long term? The market in certain neighborhoods was so much better for families. Did I enjoy cooking? She had a wonderful woman who had helped her with recipes over the years. She would be happy to connect us. Once early on, she asked me whether I thought my work schedule left enough room for the things that really mattered in the long run, and when I asked her to be more specific, she looked at me with that particular brand of Constance Bastian patience and said, "Oh, you know what I mean, Vivienne." I did know. I chose not to confirm it. Devlin was the most interesting of the three. He was not unkind to my face, he was actually fairly charming, the kind of person who is socially intelligent enough to know that obvious hostility creates problems. But Devlin had a way of referring to my work that slowly revealed how little he thought of it. He called corporate law paperwork once, laughed when he said it, and looked at Elliot instead of me when he did. He asked me once with genuine curiosity whether I had ever considered getting into something with more impact. When I asked what he meant, he said, "I don't know, something you could actually see." I thought about the $90 million restructuring and the 230 jobs it had preserved and said nothing. I smiled. I had a glass of wine. If you have ever been counted out by the people who were supposed to welcome you, you know exactly what that smile costs. And you know exactly why you sometimes choose to keep it. The pattern continued for about 18 months. Elliot and I settled into our life in Charlotte. We bought a house. I contributed 60% of the down payment from my own savings, a fact that I noted quietly and did not announce. I kept working. I took a position as a contractor rather than in-house counsel, which gave me more flexibility and, truthfully, more income than the salaried role had. I was not forthcoming about this with the Bastian family because I had by then learned that any information I volunteered was either minimized or used later in ways I had not anticipated. The pregnancy was planned. Elliot and I had talked about it seriously for most of the previous year, and when I was confirmed pregnant in the early spring of 2023, both of us were genuinely happy. My mother flew up from Charleston and cried. My father, who had been less demonstrative about most things in my life, called me 3 times in 1 week, which is his version of the same thing. The Bastian family's response was more complicated. Constance was warm in a performance kind of way. She called me, she offered to plan a shower, she sent a very expensive gift from a very recognizable boutique and mentioned the brand name when she brought it up again later. Roland shook Elliot's hand at the next dinner and said, "Good. That was it, good." Like Elliot had closed a deal, Devlin said nothing to me directly for about 2 weeks. Then, at a family gathering at Roland and Constance's house, he pulled Elliot aside. He did not know I could hear them from where I was standing near the kitchen doorway and said, "Dad is going to want to talk about the succession documents now that there's going to be a kid. You know, he's been holding off on that." Elliot said something I couldn't catch. Devlin said, "I'm just telling you. He wants it done before the baby." That's all I'm saying. I walked back into the kitchen and stood at the counter for a moment with my hand on my stomach. My daughter turned over. She was already moving by then, already making her presence felt in the most physical and immediate way, and I thought, succession documents, before the baby. I filed it. I did not react. I went back to the dining room and accepted Constance's offer to help me with the registry, and I smiled at Devlin when he came back to the table, and I was charming and gracious for the rest of the evening. That night at home, I opened my laptop and wrote 3 words in a document I kept password protected: succession, timing, why. I did not know yet what I was looking for, but I knew how to look. That was the first week of June 2023. What happened next took about 5 months to fully reveal itself, and by the time it did, I had a file that was 43 pages long and a lawyer who had already drafted the letter. But I am getting ahead of myself. Let me tell you about the night it started. The first time I understood that something was genuinely wrong, not just uncomfortable, not just the ordinary friction of marrying into a family that had not expected you and was not entirely pleased, was a Saturday afternoon in late July of 2023. I was about 5 months pregnant. Elliot was in Raleigh for a 3-day consulting engagement and had asked me to attend a family dinner at Roland and Constance's house in his place to keep the relationship warm, because Elliot is the kind of person who believes that presence is the same as goodwill. I went. I brought wine and a dessert I had made myself, which Constance accepted with a look that said she appreciated the effort while being somewhat uncertain about the execution. It was Roland, Constance, Devlin, and Devlin's girlfriend at the time, a woman named Tara Feld, who was perfectly pleasant and had the instinct common to people in uncertain social positions of staying very quiet and agreeing with whoever was speaking. The dinner was fine until it wasn't. We were about halfway through the main course when Roland set down his fork. Not fast, not dramatically, he just placed it on the rim of his plate with deliberate care, the way he did when he was about to say something he had been holding back. Vivienne, he said, I want to talk to you about something. Constance had a sudden interest in her napkin. Of course, I said, my voice was completely even. Elliot tells me you're still taking work. I am. Contract work, yes. Roland looked at me for a moment. How much longer are you planning to do that? Through the pregnancy, most likely, possibly after, depending on how things settle. He stopped, started again. I think Elliot should probably be the one you discuss your plans with, not me. But since you're here and he isn't, I'll just say that we've been a family where the children are the priority. That's not a judgment. That's just how we've done it. I set my own fork down slowly. I appreciate that. Elliot and I are very much aligned on prioritizing our child. I'm sure you are. He picked up his fork again. I just want to make sure that the focus stays where it belongs. Devlin was looking at his plate. Tara Feld was looking at her water glass. Constance had finished with the napkin and was now looking at a point somewhere slightly above my left shoulder. I understand your perspective, I said, and I meant that in a much more literal way than Roland realized, because what I understood in that moment was that he had just told me in the very specific language of men who believe they are being reasonable, that my professional existence was an inconvenience to his vision of what his grandchild's mother should look like. The dinner ended. I drove home. I added 4 more words to my document: control, erasure, labor, proof. I called my attorney the next morning. Her name is Renata Osiembiki, no relation to me. The shared surname is a coincidence that I have always found comforting, and she had been my lawyer for personal matters for about 3 years by then. She is thorough, she is calm, and she does not waste words. I told her what Roland had said. I told her about the succession document comment from Devlin. I told her about the pattern I had been noticing. Renata listened without interrupting. Then she said, are you asking me to do something specific, or are you cataloging? Cataloging for now, I said, but I want you ready. I'm always ready, she said. Keep notes with dates, everything. I already was. What I did not know yet, and what I would not fully understand until much later, was that the dinner conversation about my work schedule was not Roland expressing a general preference. It was Roland managing a timeline. He was already, at that point, in the process of restructuring the Bastion development ownership documentation in a way that was designed to exclude any future claim by a grandchild born to Elliot and me, while simultaneously funneling a significant portion of the company's revenue through a set of offshore accounts that did not appear in the company's official financial reporting. I'm going to say that again so it lands properly. While my father-in-law was sitting at his dinner table explaining to me that my career was a distraction from family values, he was actively defrauding the company that his son, my husband, was a partial owner of. He was hiding money. He was doing it with Devlin's knowledge and cooperation. And the succession documents that Devlin had mentioned were not being updated to reflect a growing family. They were being rewritten to cut Elliot out. But I did not know that in July. In July, I knew only that something was wrong, and I had a document with 7 words in it and a lawyer on retainer. The second significant moment came 6 weeks later on an afternoon in early September. I had developed by this point a quiet habit. Every few weeks, I would review the publicly available filings for Bastion development, annual reports, property transfer records, anything that was part of the public record. I was a finance attorney. Reading these documents was not unusual for me. It was, in fact, how I relaxed, which Elliot found both impressive and slightly concerning. On this particular afternoon, I was sitting in our living room with my feet elevated. The pregnancy had entered the stage where my ankles were conducting an ongoing experiment in how large they could become, and I was going through the most recent annual filing for Bastion development that was available on the State Business Registry. Something was off. The reported revenues for the previous fiscal year were lower than they should have been. Not dramatically, not the kind of variance that would flag in a routine audit if no one was looking closely, but I had been following this company for 3 years by then, and I knew their properties. I knew the rental rates in the markets they were operating in. The numbers I was looking at represented approximately a 12% underreporting of what those properties should have generated based on public market data. 12%. On $40 million in assets, the real number, not the filed number, 12% is approximately $4.8 million. I closed the laptop. I opened it again. I went back through 2 more years of filings. The pattern held. It was not accidental rounding. It was not a bookkeeping error that had been allowed to persist. It was deliberate, it was consistent, and it had been happening for at least 3 years. My hands were steady when I called Renata. I have thought about that since, the fact that my hands were steady. I think it was because I had been waiting for something concrete, and concrete things are easier to hold than vague ones. I need a forensic accountant, I told her. A brief pause. How current is what you're looking at? 3 years minimum. Possibly longer. Another pause, longer this time. Are we talking about your father-in-law? Yes, Vivienne, her voice was careful. This is your husband's family. I know. And your husband, does he know what you're— I don't know what Elliot knows, I said. That is one of the things I need to find out, but I need the accountant first. She was quiet for a moment. Then, I know someone. Her name is Priya Chandrasekharan. She's one of the best I have ever worked with, and she does not talk. When can she start? I'll call her today. I put the phone down and looked out the window at our backyard. September in Charlotte is still warm, and the light was doing something specific with the oak trees that I remember very clearly. My daughter kicked twice in quick succession, like punctuation. I said out loud to no one, "Okay, let's find out." If I had known then how deep it went, I might have moved faster. But I also might have moved wrong, and moving wrong would have cost me everything. The 43-page file did not build itself in a day. It built itself in 83 days of methodical, careful, documented work that I conducted in the early mornings before Elliot woke up and on the evenings when he had work calls, seated at the small desk in the room that would become my daughter's nursery, with a cup of herbal tea and a growing sense of cold, focused clarity. Let me tell you about those 83 days. Priya Chandrasekharan came on board in the second week of September. She was 41, had a master's degree in forensic accounting from Georgia Tech, and had spent 7 years working with the FBI's Financial Crimes Division before going private. She wore reading glasses on a chain around her neck and had a habit of tapping her pen cap against her lower lip when she was working through something. In our first meeting, she looked at the 3 years of filings I had compiled, the property valuation data I had pulled from public records, and the notes I had been keeping since June, and she said, "How long have you been doing this? Putting together what I have here, about 6 weeks. No, I mean, how long have you been doing this kind of work? 15 years, more or less." She nodded and tapped her pen cap twice. "Okay, give me 10 days. She came back in 8. What Priya found in those 8 days was the beginning of a picture I could not have completed alone. The 12% underporting was only the surface layer. Beneath it was a second structure, a set of transactions, rooted through a holding company registered in the Cayman Islands, that had been systematically diverting revenue from 4 of Bastion Development's highest performing properties into accounts that did not appear anywhere in the company's official records. The holding company, incorporated under the name Hartwell Property Services Limited, which meant nothing to anyone unless you knew to look for it, had been active for 4 years and 2 months. The total diverted over that period, based on Priya's preliminary analysis, was somewhere between $3.2 and $3.8 million. She said the final number would likely be higher once she had access to more complete records, but she wanted to be conservative until she could verify the transactions directly. $3.2 million, minimum. I sat with that number for a long time after Priya left. Elliot was a partial owner of Bastion Development. He held a 22% stake, inherited from a buyout arrangement with his grandfather's estate, which had been completed before Roland fully consolidated control of the company. This was not general knowledge within the family, actually. Roland referred to Elliot as not involved in operations, which was technically true but legally irrelevant to Elliot's ownership interest. Elliot himself did not seem to fully grasp the significance of his stake. He treated the quarterly distribution checks, which had become increasingly modest, as a kind of peripheral inheritance income rather than as evidence of an ongoing ownership relationship. I had known about the 22% since Elliot and I became serious. I had read the documentation. I had understood what it meant. I had been waiting to understand what Roland understood about what it meant. Now I was beginning to. The distributions Elliot received had dropped by approximately 31% over the previous 3 years. Roland's explanation, offered once at a family dinner when Elliot had cautiously raised the topic, was that market conditions had been difficult and the company had needed to reinvest heavily in infrastructure. Elliot had accepted this. I had noted it. And now I was looking at a forensic accounting preliminary report that suggested the actual revenues had been doing nothing of the kind. Priya recommended that we continue gathering. She had a contact at a title company who could help verify certain property transfer records, and she wanted to trace the Hartwell entity further before we drew any final conclusions. I agreed. I told her to keep going. Meanwhile, I kept attending family dinners. This is the part that people find hardest to understand when I tell this story. How did I sit across from Roland and Constance and Devlin, week after week, while knowing what I was beginning to know? How did I eat Constance's lamb and discuss the Highlands renovation and nod when Roland told Elliot about the Henderson Street project, when I had a folder on my laptop that was growing more damning by the day? The answer is that I had something to protect. 2 things, actually. My daughter, who was growing more real and more present with every week that passed, and my husband, whose father was stealing from him and who did not know it and who was going to need to know in a way that gave him options rather than simply detonating his entire family in front of him without warning. I thought about telling Elliot often. I rehearsed versions of the conversation. But every time I came close, I ran into the same problem. I did not yet know how much Elliot knew. I did not know whether his apparent ignorance was genuine or performed. I did not want to tip my hand to someone who might, however reluctantly, feel the pull of loyalty toward his father over loyalty toward me. These were not comfortable thoughts to sit with. They were also not thoughts I could afford to avoid, so I continued. I documented. I went to my desk in the small room that smelled like new paint. We had just finished priming the walls for the nursery, and I worked. In October, Priya gave me the Cayman account details. She had obtained them through a source I will not name but whose work I would vouch for, and they confirmed what the preliminary analysis had suggested. 4 accounts, 31 transactions over 4 years. The total at that point was $3.6 million, and the accounts were still active. The accounts were held in the name of a man named Gerard Voss. Gerard Voss was Roland Bastian's college roommate. He had been living in the Cayman Islands since 2015 and had no apparent business relationship with Bastion Development in any of its official documentation. He did, however, have a daughter who was enrolled at a private school in Charlotte, whose tuition was paid by a wire transfer from one of the 4 accounts. That transfer crossed a line from offshore structuring into domestic education expense in a way that created a paper trail visible to anyone looking for it. Priya had found it because she was looking for it. She set a printed page on the desk between us and pointed to a row of numbers without speaking. Then she looked at me over her reading glasses and said, "This is federal." "I know," I said. "This is not a family dispute anymore." "I know. What do you want to do with it?" I thought about Roland at his dinner table, setting down his fork with that deliberate care. I thought about Constance and her napkin. I thought about Devlin saying Dad is going to want to talk about the succession documents before the baby. I thought about the quarterly distributions that had been quietly declining for 3 years while the real money went somewhere else. "I want it documented completely," I said. "Every transaction, every entity, every name. I want a report I could hand to a regulator and have them understand in one reading." Priya tapped her pen cap. 3 weeks. Take 4 if you need them. But be thorough. She was thorough. She was also 3 days early. By the first week of November, the file was 43 pages long. It contained a complete transaction history for the Hartwell Property Services account spanning 4 years and 2 months, the names and documentation for all 4 Cayman accounts, Gerard Voss's identity and his connections to Roland Bastian, the specific properties whose revenue had been diverted, and the differential between reported and actual income, a timeline of Elliott's declining distributions correlated against the offshore transfers, and 12 pages of cross-referenced notes in Priya's handwriting that linked every piece of evidence to a specific legal category of violation. Wire fraud, securities fraud because 2 of the 4 properties were collateral for a bond offering that had used the falsified financials, and tax evasion, though Priya noted that the IRS implications were secondary to the SEC and DOJ exposure. Renata, when I sent her the file, called me within 2 hours. Vivienne. Her voice was doing something I had not heard from her before, a kind of controlled intensity, the way a person sounds when they are trying to be calm about something that does not feel calm. "Where did you get this?" "From work I've been doing since September." Priya Chandrasekharan put it together. A beat. "Priya is very good. I know. This is enough to refer. I know that too. Before you decide anything, I need you in my office. Tomorrow, if possible. I'll be there at 9. Renata's office is in an older building downtown that has not been renovated in the way that newer firms renovate. No standing desks, no exposed brick, no decorative plants. It has wood paneling and a large conference table and bookshelves that go from floor to ceiling on 2 walls and contain actual books. I have always found it calming in the way that functional, serious rooms are calming. She was waiting for me when I arrived with coffee and Priya's report already printed and tabbed. "Tell me where Elliot is in this," she said. Not a greeting, she had moved past pleasantries. "I don't know, that's honest. You need to know before you file anything. I understand that. If he has any knowledge of the offshore accounts, any at all, he has exposure, which means you have exposure. I've been thinking about that." Renata looked at me steadily. She had known me long enough to understand that when I say I have been thinking about something, I do not mean I have been worrying about it. I mean I have been constructing a response to it. "What are you thinking?" "I need to talk to Elliot before anyone files anything. I need to do it in a way that gets me an honest answer, not a defensive one." "How do you plan to do that?" "Carefully," I said, "and soon, because something else is happening." I told her what I had begun to suspect in the previous 2 weeks. In early October, Constance had mentioned, twice in 2 different conversations, something called the estate planning update, a phrase she used in a tone that suggested she was reminding me of something I already knew, which I did not. I had asked Elliot about it casually, and he had been vague in a way that was unusual for him. He was not a secretive person by nature. The vagueness had its own texture. Renata listened and then said, "You think the succession documents are already being redrawn?" "I think they may have been redrawn. I think the timing, the offshore accounts, the declining distributions, the estate planning, I think it's coordinated." Renata was quiet for a moment. "To cut Elliot out. To cut Elliot out," I said, "and therefore to cut my daughter out before she's born." Renata put her coffee down. She looked at the tabbed report. She looked at me. Vivienne. If that's true, if they have already completed revised succession documents while simultaneously defrauding the company, that is a level of exposure for Roland Bastian that I don't think he has fully reckoned with. No, I agreed. I don't think he has. I drove home from Renata's office that afternoon with the kind of clarity that comes not from certainty about outcomes, but from certainty about your own position. I knew what I had. I knew what it was worth. I knew the sequence of steps that needed to happen. I knew that I needed to talk to Elliot, and I knew how I needed to do it, and I knew that the window before the baby arrived was closing. My daughter was due on the 23rd of December. It was the 7th of November. I had 16 days before everything was going to change, before a small person arrived in the world who would need my full attention and my full presence, and before whom I was not willing to perform a family lie for even one additional day. 16 days. I sat in the car in our driveway for a few minutes after I turned off the engine. The afternoon light was doing the thing again with the oak tree. I put my hand on my stomach. My daughter was still. I thought, be careful, be precise, be ready for every version of what comes next. Then I went inside. The conversation with Elliot happened the following evening. I had spent 24 hours deciding how to frame it, which sounds clinical but was actually one of the harder things I have done, because what you are really deciding, when you are that deliberate, is what kind of person your husband is. You are deciding how much truth to offer and in what order, and the sequence you choose says a great deal about how much you trust someone. I trusted Elliot. I had some uncertainty about what he knew. Those two things can coexist, and I needed to act on both of them simultaneously. I cooked dinner. Nothing special, pasta, the kind we had on weeknights when neither of us felt like thinking hard about it. We ate and talked about his week, and I waited until he was relaxed in the particular way he got relaxed on weeknights, when the work brain had loosened a little, and then I said, "Can I ask you something about your father's company?" He looked up. "Sure. The quarterly distributions. They've dropped about 30% over 3 years." A small pause, not defensive, more like the pause of someone shifting attention to something they have not been thinking about. Yeah. Dad said it's been a rough few years for development. Rates went up, projects got more expensive. Do you have the distribution agreements, the original documents from when you inherited the stake? He looked at me with slight curiosity. Probably somewhere. Why? I want to look at them. Another pause. This one had more texture. Vivienne, is something wrong? I looked at him across the table. I thought about 16 days. I thought about my daughter. I thought about $3.6 million in 4 Cayman accounts and a man named Gerard Voss whose daughter went to a private school in Charlotte. I found something, I said. I need you to listen to me without panicking because I have it handled, but I need you to know what I know. Elliot set his fork down. He looked at me with the full, specific attention that had made me fall in love with him in a hotel bar in Atlanta 4 years ago. Okay, he said, tell me, I told him. Not everything, not the Cayman details, not Priya's name, not the full scope of the 43-page file, but enough: the underreporting, the declining distributions, the offshore structure I had identified, the Hartwell entity. He was very quiet while I talked. He did not interrupt. When I finished, he was still quiet for a long moment, and then he said, and I want to be precise about this because the specific words he used told me everything I needed to know about where he stood. How long have you known? Not, are you sure? Not, that can't be right. Not, maybe there's another explanation. How long have you known? Since September, I said. I hired a forensic accountant. Something moved across his face that I could not fully read. It landed somewhere between recognition and grief. He said very quietly, I thought there was something wrong with the numbers. You did. 2 years ago, I asked my father about the distribution drop. He gave me the same answer: market conditions, reinvestment. I let it go. He looked at the table. I let it go. Elliot, did you know about the offshore accounts? He looked up at me. No, flat, clear, no hesitation. No. I knew the numbers didn't add up, and I let it go because it was easier than fighting with him, but I did not know where the money was going. I believed him. I still believe him. It was the kind of answer that comes from a specific kind of shame, not the shame of being caught doing something wrong, but the shame of recognizing that you knew something was wrong and chose not to see it. Okay, I said. Okay, that's Vivienne. What do we do? That depends on what you want. He looked at me for a long moment. What do you think we should do? I think we have an obligation to report what I found. Not because of what it does for us financially, though it does matter for our daughter's future, but because this is fraud. It's ongoing fraud, and the people who would know to stop it don't know it's happening. He was quiet again. He rubbed the back of his neck, which is his equivalent of the deep breath someone else might take. My brother, he said. Does Devlin know? I think so. I don't have direct evidence yet, but the succession document conversation you told me about, the timing lines up. Elliot closed his eyes for a moment. When he opened them, something had resolved in his expression. The grief was still there, but it had moved aside for something quieter and more certain. Tell me what you need from me. I need the original distribution agreements, and I need you to not mention any of this to your father or Devlin until I tell you it's time. How long? 12 days, maybe fewer. He nodded. He picked up his fork. He ate 2 bites of pasta. Then he said she's going to have the Bastion name our daughter. She is. I want it to mean something good, not this. I reached across the table and put my hand over his. He turned his hand over and held mine. We sat like that for a moment in the quiet of our kitchen with the sound of the neighborhood outside and the weight of what was coming, and I thought, this is the thing worth protecting. Not the money, not the name, that moment stays with me. It is the one I go back to when people ask whether I regret how things unfolded. I do not regret it, but I am glad I had that moment first. Elliot found the distribution agreements in a box in the garage the following morning. He photographed every page and emailed them to me before 7 with a note that said, "Let me know what else you need. No drama, no second guessing. Just, what do you need?" I forwarded the documents to Renata. In the meantime, Priya had completed 2 additional pieces of analysis. The first was a tracking of the Hartwell entity's corporate registration history, which revealed that it had originally been registered in the names of both Roland Bastian and Gerard Voss as equal shareholders, then had been restructured 14 months ago to list Devlin Bastian as a 25% stakeholder. Devlin had known. He had not just been aware of the offshore arrangement, he had a direct ownership interest in the vehicle being used to conduct it. The second piece of analysis was the one that changed my understanding of the timeline entirely. Priya had obtained, through the title company contact, copies of recent amendments to the Bastion Development corporate documents. The succession and ownership structure had been revised in September, 6 weeks before our dinner conversation, where I told Elliot what I had found. The revisions had reduced Elliot's ownership stake from 22% to 7%, on the basis of a document that characterized his original inheritance as having been subject to a performance clause, a clause that appeared nowhere in the original inheritance documentation, and that Elliot had certainly never been told about. Someone had inserted a clause into a legal document that had not existed when the document was originally executed. That is not an estate planning update. That is forgery. I sat with that for a full hour before I called Renata. The succession documents, I said when she picked up. The revision in September. There is a performance clause in the amended version that does not appear in the original. A silence. The kind that means someone is being very careful about their next words. You have both versions. Priya has both versions. She obtained certified copies of the original from the county recorder's office and the amended version through the title company contact. Those are 2 different documents purporting to represent the same original agreement. Yes, Vivienne, Renata's voice was doing the controlled intensity thing again. That is document fraud, in addition to the wire fraud and the securities violations. I know, this is no longer just an SEC matter. I know that too. I want to file within the week. The longer this sits, the more opportunity there is for Roland to move assets or destroy records. I agree, I said, but I need to talk to you about the sequence first, because something else is about to happen and I want it to happen on my terms. What's about to happen? Roland has invited Elliot and me to family dinner on Saturday. It will be the full family, Roland, Constance, Devlin, and a family attorney named Hugh Carper. Elliot has been told that this dinner is to present the updated estate planning documents. He does not know what I know about those documents. Renata was quiet. Roland is going to present Elliot with the amended succession documents at that dinner, I said. He is going to explain the performance clause as a long-standing condition of the inheritance. He is going to have Hugh Carper there to make it official. He expects Elliot to accept it, and you are planning to be at this dinner. I am planning to be at this dinner. 8 months pregnant. 8 months and 1 week, yes. Another pause. What are you going to do? Nothing, I said. I am going to go to that dinner and eat the food and let Roland present his documents and say nothing. I am going to give him the full performance of compliance. And then on Monday morning, I am going to send 1 email. Renata made a sound that was not quite a laugh. You have thought about this. I have thought about almost nothing else for 83 days. Okay, she said. Walk me through it. I did. By the time we finished, it was past 10 in the evening, and my daughter was doing what she always did at that hour, which was shift her position in a way that pressed against the left side of my ribcage with specific insistence, as if reminding me she was monitoring the situation. Saturday arrived. I wore a navy dress that I had bought specifically for the later stage of the pregnancy. It was comfortable and looked serious at the same time, which felt appropriate. Elliot drove. In the car, he asked me once quietly whether I was okay. I told him yes. He did not ask what I was planning because I had asked him not to know, and he trusted me enough to honor that. I think about that too sometimes. The specific quality of trust required to sit in a car and drive toward the thing that is going to change everything, without asking too many questions, because you believe in the person next to you. Roland and Constance's house in the evenings had a particular quality to it: warm lights, the smell of whatever Constance had been cooking, the sounds of a family home operating in the way family homes do when they believe themselves to be secure. We arrived at 6:30. Hugh Carper was already there, standing near the fireplace with a glass of water and the careful posture of a professional who is being paid to be present. He was about 60, gray-suited, the kind of man who had been doing estate law long enough that nothing surprised him, or so he thought. Devlin was there. He watched me come through the door with a look I had learned to read over 3 years, the quick assessment, the micro adjustment of his expression to something pleasant and neutral. His tell, I had come to notice, was a very small gesture with his left hand when he was uncertain. He would turn his ring, a signet ring, inherited from his grandfather, a quarter turn on his finger. He did it when I walked in. He did it again when Elliot embraced Roland. Constance had made lamb again. I noted it. I accepted it. I ate it. The dinner was unusually warm, looking back. Roland was expansive, telling stories, asking Elliot about his work in a way that was more engaged than usual, pouring wine generously. Constance smiled often. Devlin kept his hand away from his ring for most of the meal. Even Hugh Carper, who had maintained his professional remove through the appetizers, seemed to relax by the second course. I understood what it was. It was the warmth of people who believe they are about to win something cleanly. It has a very specific quality. It loosens people. It makes them generous in the way that people become generous when they are not worried about the cost. I ate my lamb and said very little, and when Constance told me I looked wonderful and that pregnancy suited me, I thanked her and meant nothing and watched everything. After dinner, Roland asked Elliot and me to join him and Hugh in the study. Devlin came too. Constance excused herself. She had always had a talent for being elsewhere during the specific moments when business was conducted, a skill that gave her later a great deal of latitude to claim she had not known what was happening. Roland's study had a desk and 4 chairs and shelves of books that I doubted had been read recently. Hugh Carper opened a leather portfolio and produced a set of documents, clean, tabbed, professional. He explained the amended succession structure in the practiced language of estate attorneys. The original inheritance had contained, he said, a performance clause requiring Elliot's active participation in the company's operations as a condition of his full ownership stake. Given Elliot's decision to pursue consulting work rather than joining the company, the clause had been triggered, resulting in the reduction of his stake to 7%. Elliot listened. I watched his face, the careful stillness he was maintaining because I had asked him to let me handle it. Roland said expansively, "It is what Dad intended. It is just being properly documented now. There is nothing to be upset about." Hugh Carper slid the documents across the desk toward Elliot with a pen. There was a silence in the room. Devlin turned his ring a quarter turn. Roland folded his hands on the desk with the satisfaction of a man who is watching a plan arrive at its conclusion. I was sitting to Elliot's right. I looked at Hugh Carper. I looked at Roland. I looked at the documents. I looked at the pen. I smiled. "Elliot," I said very gently, "you don't need to sign anything tonight." Roland's expression did not change exactly, but something in it recalibrated, a slight tightening around the eyes, a pause before he spoke. "Vivienne, this is a family matter." "It is," I agreed. "I'm family. What I mean is, this is between Elliot and his father. There are legal complexities that—" "I'm a corporate attorney," I said. "I'm quite comfortable with legal complexities." Hugh Carper was watching me with the particular attention of someone who has just realized the room is different from the one he thought he walked into. "You don't need to sign anything tonight," I said to Elliot again. Then I looked at Roland, and my voice stayed completely even. "I want you to know that, completely even," and I said, "I'd like to recommend that Elliot review these documents with independent counsel before executing anything." Given the discrepancy between these amended terms and the original inheritance documentation, the room was very quiet. Roland said, "There is no discrepancy." "The original documents don't contain a performance clause," I said. "I have certified copies from the county recorder's office." Roland looked at me across his desk. He looked at Hugh Carper. Hugh Carper had stopped writing something he had been writing on his legal pad. He just stopped mid-stroke and looked at the document in front of him. Devlin's hand went to his ring. He turned it a full half rotation this time. I stood up slowly, carefully, because 8 months and 1 week is a specific physical state that requires certain considerations, and I picked up my coat and I said, "I think it would be best if Elliot and I headed home. Thank you for dinner, Constance." I could hear Constance's voice from somewhere toward the kitchen. "Oh, so soon?" Elliot stood. He looked at his father for one long moment, with an expression I cannot fully describe, but that had in it something final, something that had crossed over from son to adult and was not going back. Then he followed me out. In the car, he said nothing for several minutes. Then, "The performance clause is not in the original document," I said, "which means someone added it." "Yes," he drove. "The Charlotte streets at 9 in the evening have a certain quiet." "Monday," he said. "Monday morning," I said. 9:15, he nodded. He put his right hand briefly on mine where it rested on the center console, and then he put it back on the wheel. I looked out the window at the city going past and thought about an email I had already drafted, sitting in my outbox, addressed to the Securities and Exchange Commission's Office of the Whistleblower, with Priya's 43-page report attached as a PDF. All it needed was one button. Monday morning, I woke up at 6. My daughter was awake too. She had been developing strong opinions about my sleep schedule for several weeks. I made coffee. I sat at the desk in the nursery, which by this point had yellow walls and a white crib and a small lamp that Elliot had assembled with great concentration over an October weekend. I opened my laptop. I looked at the email for a few minutes, then I pressed send. I also forwarded the same report, specifically page 4, which contained the transaction history cross-referencing the offshore accounts to the specific Bastion Development properties and the corresponding entries in the falsified annual filings, to the 3 independent board members of Bastion Development with a cover note that read, "I believe the attached is material to your obligations as board members and wanted to ensure you had the opportunity to review it before the next board meeting. Please confirm receipt." I closed the laptop. I finished my coffee. I went back to bed for another hour. Roland called Elliot at 8:47 in the morning, which I know because I was making toast when Elliot looked at his phone and said quietly, "It's my father." He looked at me. I nodded. He answered. I did not hear Roland's side of the conversation. I heard Elliot say 3 times in 3 slightly different versions of the same tone, I understand, Dad, I hear you." And then after a silence, "I can't undo what's already been sent." He hung up. He put the phone face down on the counter. He looked at me. "He knows," Elliot said. "One of the board members called him." I said, "It wasn't a question. One of the board members called him." Elliot picked up his coffee, held it without drinking. It's not good." "No," I said, "it won't be." "Vivienne," he said. Elliot stopped. His jaw tightened. "He told me that you had no right. That you did this to destroy the family. That you," he stopped again. I waited. "That you should leave," he said. "That's what he said. You should pack your things and leave because you have no place in this family." I was silent for a moment. I was 8 months and 2 days pregnant, standing in my kitchen in the house where Elliot and I had a mortgage and a nursery with yellow walls, and my father-in-law, who had been defrauding his own son for 4 years, had just told me I had no place in the family. I felt something arrive in my chest, not anger exactly, something steadier and more certain than anger. The kind of feeling that tells you exactly where you stand and exactly what you're not willing to accept. I looked at Elliot. "What did you tell him?" Elliot set down his coffee. He looked at me with the full specific attention I had fallen in love with in Atlanta. "I told him," he said, "that you are my family. I have thought about those 5 words many times since then. They are still to me the most important thing that was said across any of the conversations that followed, the calls with Renata, the SEC inquiry, the board investigation, the attorneys, the eventual settlements. All of it, 5 words on a Monday morning in November over toast. You are my family." Renata called at 10:15. "I've heard from the board," she said, "all 3 independent members. They've retained outside counsel and called an emergency board meeting for Wednesday." "Good." Vivienne, the SEC acknowledged receipt of the complaint this morning with a case reference number. "Also good. Hugh Carper called me directly about 40 minutes ago." There was something in her voice that was very close to satisfaction. "He withdrew from the estate amendment matter and declined to discuss the succession documents further. He cited a need to review his own professional obligations." Hugh Carper, in other words, had looked at the 43-page report and realized that he had been asked to serve as the notary for a forged document, and that continuing to represent Roland Bastion in any capacity was professionally untenable. "And Priya?" I asked. "She is available to appear as an expert if needed. She says," and I am quoting her directly here, "that the transaction trail is one of the cleanest forensic reconstructions she has assembled in 11 years of private practice." I thought about Priya's reading glasses and her pen cap tapping against her lower lip. "Tell her thank you." I already did. The 4 days that followed were, to be honest, something I struggle to fully describe. They had the quality of time that moves both very fast and very slow, each hour containing more events than it should have, while the overall shape of things seemed to be assembling itself with a kind of inevitability that made urgency feel almost beside the point. The thing was already in motion. What mattered now was staying steady. Devlin called Elliot on Tuesday. The conversation lasted 11 minutes. I know because Elliot told me, and because Elliot, like me, had a habit of noting specific details. Devlin's position, as he presented it to Elliot, was that the offshore accounts had been a necessary business arrangement, that everyone had benefited, that Elliot's declining distributions had been a function of accounting complexity rather than diversion, and that Vivienne, he used my name, had caused irrevocable damage to the family by going to regulators without attempting to resolve things internally first. Elliot told him that there was nothing to resolve internally in the presence of a forged document. Devlin said that the performance clause had been Roland's interpretation of the original intent, not a falsification. Elliot said that interpretation was not the same as insertion. The call ended. Wednesday morning, the Bastion Development Board convened. Roland was present. He had not yet been formally removed from anything, which was a reality that the board's outside counsel was working to address. The outside counsel presented the preliminary findings from Priya's report, which had been transmitted to them by Renata. Roland's attorney, a different attorney, not Hugh Carper, attempted to characterize the offshore arrangements as authorized by Roland as majority stakeholder. The board outside counsel pointed out that Roland held 44% of the company. The other 56% was held by Elliot and by two other legacy shareholders, cousins from the original family business, who had been largely passive investors for 20 years and had just been informed that their passive investment had been quietly defrauded. The board voted to suspend Roland's executive authority pending a full investigation. 6-0. Roland's attorney abstained from comment. Renata told me this at 2:15 on Wednesday afternoon. I was sitting in the nursery at the time, assembling a small bookshelf that I had been putting off for 2 weeks. My daughter was doing her late afternoon routine, which involved a series of movements I had come to think of as her processing the day's events. 6-0, I repeated. 6-0, Renata said, and the outside counsel wants to speak with you directly on Friday. They are considering seeking an injunction to prevent any further movement of funds from the company accounts pending the investigation. That's appropriate, I said, and tightened a bolt on the bookshelf. Thursday morning, a lawyer I had never spoken to before called my cell phone. He introduced himself as Nathan Hale, an unfortunate name for an attorney, I thought, though I did not say so, and said he represented a party connected to the Hartwell Property Services matter. He said his client wanted to discuss a resolution that would be mutually beneficial. He said his client understood that the situation had become complicated and wanted to be constructive. His client, I understood, was Gerard Voss. I appreciate the call, I said. Please send anything in writing to my attorney, Renata Oskembicki. Her contact information is publicly available. There was a brief pause on the line, of course. I just want to say my client is very motivated to reach a resolution quickly, given the circumstances. I understand, I said. Renata's information is publicly available. He called Renata within the hour. By Friday morning, she had received a written offer of cooperation from Gerard Voss, who was prepared to provide full documentation of the offshore account structure, the authorization chain for all 31 transactions, and the email correspondence between himself and Roland Bastian spanning the 4-year period, in exchange for cooperation consideration. Voss, it turned out, had kept everything, every email, every wire authorization, every communication. He had kept it because he was a careful man who had lived in the Cayman Islands for 11 years and understood that careful men keep documentation of the things other people might later want to deny. It was in his documentation, obtained legally through the cooperation agreement and reviewed by both Renata and the board's outside counsel, that we found the full 4-year correspondence between Roland Bastian and Gerard Voss. It was detailed, it was explicit, it left almost no room for alternative interpretation. It also, in an email from September of the previous year, 1 month before the succession documents were amended, contained a line from Roland to Voss that read in full, "The Caro woman has been asking questions. Time to close the Elliot chapter before the baby complicates things." The Caro woman. I read that email on a Friday afternoon, 8 months and 1 week pregnant, sitting in Renata's office with wood paneling and floor-ceiling bookshelves. I read it twice. I set the paper down. Renata was watching me. "Vivienne, I know," I said. "Are you all right?" I thought about whether I was all right. I looked at the paper on the table. I thought about Roland at his dinner table, setting down his fork. I thought about the word good when he learned about my pregnancy. I thought about the Caro woman and closed the Elliot chapter and the specific deliberate cruelty of a man who had looked at my daughter's existence as a complication to be managed. "Yes," I said, and I meant it. Because the thing about reading a document that crystallizes everything is that it removes the last small uncertainties. I had been carrying a weight of doubt, not about my choices, but about whether I had understood the situation correctly, whether the full picture was as clear as I thought it was. The email removed the doubt. The picture was clear. I was all right. I was more than all right. I was exactly where I had needed to be for 83 days, and the thing I had spent those days building was standing, and it was solid. What happens next? I asked Renata. The SEC will open a formal investigation. Given the evidence quality and the cooperation from Voss, I expect it to move quickly. The board injunction was granted this morning. No company funds can be moved or transferred without board approval until the investigation concludes. Elliot's ownership stake will need to be litigated, but given that the performance clause was inserted into a document, and we now have email evidence of the intent behind that insertion, I believe we are in an extremely strong position. "And the $427,000, I said, because I should explain what that was. "That," Renata said, "is the SEC whistleblower award calculation preliminary estimate based on the scope of the securities fraud portion of the violations, eligible on the basis of your original complaint and the quality of the documentation you provided." She looked at me steadily. "It is a minimum figure." I sat with that for a moment. "I want to be honest with you, the money was not the point. I have said that before, and I know it can sound like something people say to sound noble, but I mean it specifically and practically. I was not destitute. Elliot and I were not struggling. The money, the whistleblower award, the eventual recovery of what had been diverted from the company, the restoration of Elliot's ownership stake, none of it was the reason I had spent 83 days building that file. The reason was my daughter. The reason was that a man had looked at her existence as a complication. The reason was that Elliot had been stolen from quietly and persistently by the person who should have protected him. The reason was that I had been invited into a family and told in 100 different polite and impolite ways that I did not belong there and should not expect to, and I had decided quietly, methodically, over herbal tea at a small desk in a room that was becoming a nursery, that I was going to make that cost something. Not for revenge, for my daughter who would carry the Bastion name and who deserved to have it mean what Elliot had said he wanted it to mean. Something good. Roland Bastion was formally removed from the board of Bastion Development in January of the following year. The SEC investigation concluded with a settlement. I am not able to speak to the specific terms, but the preliminary numbers were not kind to Roland's finances. The document fraud referral went to the state attorney general's office. Devlin resigned from the company in December, before the investigation had formally concluded, and retained his own attorney, a decision that created certain complications for Roland's defense, though I was not privy to the specifics. Gerard Voss cooperated fully as promised and received the consideration his attorney had negotiated. Elliot's ownership stake was restored to 22% through an agreement mediated by the board's outside counsel. The legal fees associated with that process were covered by the company's directors' and officers' insurance, which felt appropriate under the circumstances. My daughter was born on the 21st of December, 2 days before her due date, at 6:43 in the morning. She weighed 7 pounds and 9 ounces. She has Elliot's eyes in my hands and an expression when she is thinking hard about something that I cannot attribute to either of us. It is entirely her own, specific and serious, and completely unintimidated. We named her Adiz after my father's mother. We call her Ada. She is 14 months old now, walking with great determination and specific opinions about what she wants to be holding at any given time. Constance Bastion has not asked to meet her. Elliot has found his way to a grief about his family that is quiet and dignified, and that I try not to interfere with, because it is his to carry, and he carries it carefully. Devlin sent a letter in February to Elliot, not to me, that I did not read, and Elliot summarized as an attempt at explanation that did not quite arrive at apology. Elliot keeps it in a drawer. I do not ask about it. What I think about when I think about those 83 days is not the vindication, though I would be dishonest if I said the vindication was not satisfying. I think about the small desk in the not yet nursery and the herbal tea and the specific quality of focus that arrives when you are clear about what you are protecting and why. I think about Priya's pen cap against her lower lip. I think about Renata's steady voice on the phone saying, "I'm always ready." I think about Elliot in the car on a Monday morning, his hand on mine for just a moment before he put it back on the wheel. You are my family. The thing I know now that I did not know 4 years ago is that the people who underestimate you are not your problem. They are simply people who have given you information about how much room you have to work. Roland thought the Caro woman was asking questions. He thought closing the Elliot chapter before the baby was the last move he needed to make. He thought the dinner on Saturday was the end of it. He did not know I had already sent the email. He did not know that some of us keep our powder dry for exactly the right moment, and that when that moment arrives, we do not panic and we do not perform and we do not make speeches. We just press send. But I am getting ahead of myself again. Before the email, there was one more thing that had to happen, one more scene I had to perform. And it is the scene I'm most proud of, not because of what I revealed, but because of what I did not. It was the Thursday before I pressed send, 4 days before the Monday that changed everything. Renata had called me in the late afternoon with information that shifted the sequence I had been planning. Roland is moving, she said. His attorney reached out to me an hour ago. They want a meeting tomorrow. Private. Roland, Devlin, their attorney, and you, not Elliot. Not Elliot, I repeated. They specifically requested you alone. I think they believe they can manage you more easily without him in the room. I thought about that for a moment. I thought about what it meant that Roland Bastion, who had spent 3 years treating me like a variable to be eliminated, now wanted a private meeting with me specifically. It meant he knew I had something. It meant he had not yet calculated how much. And it meant he believed, as men like Roland so often believe about women like me, that a private setting and sufficient pressure would produce compliance. Tell them yes, I said, tomorrow at 2. Vivienne, Renata's voice had a particular quality when she was weighing whether to advise against something. I want to be present. You can wait in the lobby. I want to go in alone. A pause. Why? Because I need him to think he has me cornered. A lawyer in the room changes the energy. I need him relaxed. I need him to perform. Another pause, longer. You know what you're doing. I know exactly what I'm doing. The meeting was held at the offices of Roland's attorney, a man named Clifton Greaves, who operated out of a suite on the 14th floor of a building in uptown Charlotte that was all glass and gray carpeting and the specific brand of quiet that expensive professional environments cultivate deliberately. Clifton Greaves was in his mid-50s, silver-haired in a way that was less distinguished than Roland's and more careful, with the manner of a man who was good at his job but had not yet fully assessed the situation he had walked into. He stood when I came in. Roland did not. Devlin was there, seated to Roland's left, his ring already being turned when I walked through the door. He straightened when he saw me. He had been expecting, I thought, a different version of me, something more visibly strained, perhaps. Something that would confirm what he had decided about my position. I was wearing the navy dress again. My hair was up. I set my bag on the chair beside me and sat down and folded my hands on the table and looked at Roland directly. "Thank you for coming," Clifton Greaves said. He had a yellow legal pad and a pen he had not yet uncapped. "We appreciate your willingness to discuss this privately." "Of course," I said. My voice was warm and a little tired. I had practiced the tired. "I think private is the right setting for this kind of conversation." Roland looked at me steadily. He had, I noticed, the expression of a man who is recalibrating. He had expected me to come in defensive or upset or armored in a way that would confirm I was preparing for a fight. The warmth threw him slightly. I saw it in the pause before he spoke, just a half second, barely visible, but I was watching for it. "I'm going to be direct," he said. "Please. You've been pulling at threads that don't concern you. The company's financial arrangements, the succession documents, these are matters of family business that were in place long before you came into this family and that will continue long after." He stopped, restarted with a slightly different approach. "What I'm saying is that you've created a situation that doesn't need to be as complicated as you're making it." I let a silence sit for a moment. Then, "I'm listening." Roland glanced at Clifton Greaves. Clifton Greaves uncapped his pen. "What we're proposing," Clifton said, with the smooth delivery of a man presenting reasonable terms, "is a straightforward resolution. Elliott receives a revised distribution arrangement, a fixed annual payment, structured independently of the company's reported revenues, which removes any ambiguity about the performance clause question. In exchange, any documentation you may have gathered regarding the company's financial structure is treated as proprietary business information and returned or destroyed. We sign a mutual non-disclosure, and this matter is resolved privately." I looked at the table for a moment. I let my jaw tighten just slightly. I let my breath come in a way that was slightly audible, the kind of breath a person takes when they are trying to hold something back. "What's the fixed annual payment?" My voice was quieter than it had been. I was watching Roland register that quieter voice. Roland said $140,000 a year. I looked at the table again. $140,000 a year against a 22% ownership stake in a company with $40 million in real assets, against $3.6 million diverted over 4 years, against a forged document, against wire fraud and securities fraud and tax evasion. I let my lip do something, not quite a tremble, more of a compression, the kind of thing a face does when a person is working very hard not to react. I had practiced that too. "That feels," I stopped, pressed my lips together. I wasn't expecting a number that specific. Devlin leaned forward slightly. His ring had gone still. He thought the number had landed. He thought the specific precision of it had done what Roland intended it to do, had made it feel real, official, decided. I noted the lines. I noted the stillness of the ring. "It's a generous arrangement," Devlin said. His voice had the particular texture of someone who has been holding back their turn to speak. "Given what you've been doing, honestly, we didn't have to come to the table at all. Dad chose to." I looked at Devlin. I let the look be soft and a little uncertain. "I appreciate that," I said quietly. "There are also Elliott's interests to consider," Roland said, and his voice had warmed slightly, the warmth of a man who believes he is managing a situation toward his preferred conclusion. "This arrangement protects him. It keeps the family intact. Whatever documentation you've gathered, and I don't know exactly what you think you found, I want you to understand that going to regulators or making this public would harm Elliott as much as anyone. He's a part owner. It reflects on him." I let that land. I let it appear to land the way he intended it to. I looked at my hands on the table. I thought very carefully about my face, and I arranged it into something that looked like a woman weighing a threat she had not fully anticipated. "The non-disclosure," I said slowly. "What does it cover exactly?" Clifton Greaves slid a document across the table, 12 pages. I picked it up and looked at it, not carefully, not in the way I would actually read a legal document, but in the way a person reads something when they are overwhelmed and looking for a sense of the shape of it rather than the content. It covered, in broad and carefully constructed language, all documentation, correspondence, financial records, analysis, or communications related to the internal financial operations of Bastion Development and its affiliated entities, their owners, officers, and representatives, including any offshore or international arrangements. It was, in other words, a document designed to make everything Priya had built legally inaccessible to any regulatory body to which I might want to present it. What it did not cover, and this was the thing I had told Renata to make certain of 3 days before this meeting, when I had begun to suspect that a meeting like this was coming, was any documentation that had already been transmitted to a third party prior to the execution of the agreement. I had submitted the SEC complaint the previous Monday, 7 days before this meeting. I had not told Roland that. I read the non-disclosure document with my brow slightly furrowed, in the way of a person trying to follow legal language they are not entirely comfortable with. I turned to page 7. I turned back to page 4. I set it down. I need a few minutes, I said. Roland sat back slightly. Of course. I looked at the pen Clifton Greaves had placed beside the document. I picked it up. I turned it once in my fingers. I set it down again. The annual payment, I said. Could it be structured quarterly? Roland looked at Clifton Greaves. Clifton Greaves nodded. Quarterly is straightforward to arrange. I picked up the pen again. I turned to the signature page of the non-disclosure. I looked at the line. I let my hand tremble. Slightly visibly, the specific tremor of a person who is frightened and trying to hide it. Devlin saw it. I watched him see it in the way his posture changed, a small release of tension across his shoulders, the physical language of a man who has been waiting for confirmation of something and has just received it. Okay, I said softly. And I signed. Roland exhaled. Not loudly, Roland was too controlled for that. But the exhale was there, the quarter-inch drop of his shoulders, the way he reached for the glass of water that had been sitting untouched at his right hand since the meeting began. Devlin reached across the table and offered Clifton Greaves a look that was briefly, unmistakably triumphant before he composed it into something more professional. I think that's the right decision, Roland said, and his voice had the warmth again, the specific warmth of a man who has just won something he was not entirely certain he would win. This is the best thing for everyone, including your daughter. I nodded. I set the pen down. My hand had stopped trembling because I no longer needed it to tremble. Clifton Greaves collected the documents and the signed non-disclosure with the practiced efficiency of a man processing the conclusion of a successful negotiation. He said he would have copies sent to my home address within 24 hours. Roland stood. He extended his hand across the table. I shook it. His grip was firm and brief, and he looked at me with an expression that was, in its own way, almost kind, the kindness of a person who has reduced you to a manageable quantity and can afford to be gracious about it. I'm glad we could resolve this, he said. So am I said, and I meant it in every way he did not intend. I picked up my bag. I thanked Clifton Greaves for his time. I did not look at Devlin again because I did not need to. I walked to the elevator, and when the doors closed behind me and I was alone in the mirrored box descending 14 floors, I looked at my own reflection and I breathed out slowly and I thought, 7 days ago. The complaint was submitted 7 days ago. The non-disclosure I had just signed covered documentation I had not yet transmitted to any third party. It was, from a legal standpoint, entirely valid and binding with respect to anything I might do going forward. It did not reach backward. It could not reach backward. I had confirmed this with Renata on Tuesday, and she had confirmed it with 2 additional colleagues, and the consensus was unambiguous. Roland had just paid $140,000 a year for an agreement that protected nothing he needed protected. The doors opened. I walked through the lobby. Renata was standing near the entrance with her coat over her arm and a coffee from the place across the street, which she handed to me without speaking. I took it. I walked through the door. Outside, the November air was cold and clear. How did it go? She asked, falling into step beside me. He shook my hand, I said. A pause, then very quietly, he shook your hand. He was gracious about it. Renata made a sound that was not quite a laugh. The SEC case reference is active. The board outside counsel called me while you were upstairs. They are filing the injunction application this afternoon. Good, Vivienne, he has no idea. No, I said, he does not. We walked half a block in silence. Then Renata said, you know this is going to be, when it all surfaces, it is going to be very visible. His attorney, his company, his family, it will not be quiet. I know. Are you ready for that? I thought about my daughter who was pressing her heel into my ribs with the same specific persistence she had been showing for weeks. I thought about the yellow nursery walls. I thought about Elliot saying you are my family across our kitchen table. I thought about the email sitting in my sent folder with a case reference number attached to it. I have been ready since September, I said. The injunction was filed that afternoon. The board convened the following Wednesday. Roland was suspended from executive authority 6-0, as I have already told you. And on the Monday morning that followed, I sat at the small desk in the nursery with yellow walls and I sent one email. And 4 days later, a lawyer I had never spoken to called me with a number, $427,000. That was the preliminary estimate of my whistleblower award. But that is not where the story ends. That is where it became visible, where the thing I had been building in the dark finally had to stand in the light with other people watching. That happened on a Wednesday in the third week of January. I want to tell you about it carefully because the way it happened matters to me and because the sequence of events that day contained things I had not fully planned for, responses I had not anticipated, moments that arrived without my having arranged them. Not many. I had arranged most of it, but not all of it, and the parts I had not arranged are the parts I think about most. The Bastion Development Board had called an extraordinary general meeting of all ownership stakeholders, required under the company's governing documents once a formal investigation had been opened by a regulatory body. The meeting was held at a hotel conference room in Charlotte, neutral ground, by agreement between the various attorneys involved, rather than at company offices. The room had a long rectangular table, 8 chairs on each side, a projector at one end, and windows on the west wall that let in January light in a way that made the room feel both larger and colder than it probably was. Roland was present. He had not yet been charged with anything formally, and his attorney had argued successfully that his attendance was required as a majority stakeholder. His attorney by this point was not Clifton Greaves. Clifton had withdrawn from Roland's representation in the first week of January, citing professional obligations that he did not specify but that Roland understood clearly enough. Roland had retained a new attorney, a woman named Margaret Chen, who was known in Charlotte legal circles as someone who worked difficult cases with a specific combination of aggression and procedural precision. She was in her mid-40s, wore her hair in a very clean low bun, and had been watching the doorway when I entered the room with a focused attention that told me she had been briefed on me specifically. Margaret Chen and I looked at each other for about 2 seconds. I nodded. She did not. Devlin was there with his own attorney, separate representation from Roland's, which had happened quickly enough after the board injunction that I took it as confirmation of what I had suspected about the limits of family loyalty under legal pressure. The 2 legacy shareholders, the Bastion cousins, whose names are Theodore Ewan and James Ewan, brothers who had inherited their stake from their mother who had been Roland's father's sister, were present with a shared attorney. Theodore Ewan was 61 and had flown in from Phoenix. James Ewan was 58 and had driven from Raleigh. They had been quiet, passive investors for 2 decades, receiving their small quarterly distributions and asking no questions. They were not quiet now. Theodore Ewan had the specific expression of a man who has discovered that something he trusted without thinking about was not what he thought it was. He had a yellow legal pad in front of him and had already filled 2 pages before the meeting formally opened. Elliot was there. He sat to my left. He had dressed carefully, the same careful dressing he applied to things that mattered, the ones he did not want to approach casually. He looked at his father once when we entered and then looked at the table, and Roland looked at Elliot with an expression I did not let myself study because it was not mine to interpret. Renata was there with Priya, who had brought a printed version of the full 43-page report in a bound presentation folder and had a second laptop open to the transaction records. Priya had her reading glasses on their chain and her pen in her hand, and she looked as calm as she always looked, which was the particular calm of someone who is entirely confident in their documentation. The board's outside counsel, a man named Darius Whitfield, ran the meeting. He was tall, about 50, with the manner of a person who has presided over difficult rooms before and found a way to be simultaneously authoritative and procedurally impeccable. He opened the meeting by outlining the purpose, to present the findings of the preliminary investigation to all stakeholders, to address the regulatory referrals currently pending, and to allow all parties to respond to the findings before the board took formal action. He said this in a voice that was completely neutral and completely clear, and then he turned to Priya and nodded. Priya stood. She connected her laptop to the projector. She pulled up the first slide, which was simply the name of her firm and the title of the report, Financial Misconduct Review, Bastion Development Corporation, Preliminary Findings. Roland's jaw moved, not a dramatic movement, just the slight shift of a man who has told himself he was prepared for this and is now discovering what prepared actually means. Priya began. She was precise and unhurried. She had done this before, presented forensic findings to rooms of people with conflicting interests and various levels of understanding of what they were hearing, and she had a way of building the picture incrementally that I had recognized as skillful the first time I met her. She did not lead with the most explosive finding. She led with the methodology, the data sources, the analytical framework. She gave the room time to understand what kind of evidence they were looking at before she began to describe what it showed. The first exhibit was the revenue differential analysis, the 12% gap between reported and actual revenues across the 4 highest-performing properties over 3 years. Priya walked through each property, the market data, the comparable performance of similar assets, the specific line items in the annual filings where the underreporting appeared. It was 11 slides. It took about 20 minutes. During those 20 minutes, Margaret Chen took notes with focused speed. Devlin's attorney looked at his phone once and then did not look at it again. Theodore Ewan filled another half page. Roland sat with his hands folded on the table and his expression set in something that was meant to look like patience and looked to me like a man sitting very still because moving felt dangerous. When Priya finished the revenue differential section, she paused and looked at the room. I want to give any party the opportunity to raise questions on this section before we proceed. Margaret Chen said, I have questions, but I will reserve them for the proper response period. Darius Whitfield said, noted, continue. Priya advanced to the next section. Hartwell Property Services Limited. The name went into the room and stayed there for a moment. I watched Roland. His hands, which had been folded, separated slightly. He put them flat on the table. It was a small movement, and it told me something specific. Priya explained what Hartwell was, the corporate structure, the Cayman registration, the ownership history. She put the registration documents on the screen. Roland Bastian and Gerard Voss as original equal shareholders, the restructuring 14 months prior that added Devlin Bastian as a 25% stakeholder. The names were on the screen in a room with 17 people in it, most of whom had not known those names 20 minutes earlier. Theodore Ewan put his pen down. James Yoon said quietly to his attorney, that's is that, and his attorney put a hand on his arm and he went quiet. Devlin's expression went through something I watched happen in real time, a kind of controlled collapse, where the outer architecture of composure remained in place while something behind it stopped functioning. His hand moved to his ring. He did not turn it. He just put his hand over it, covering it like he was trying to hold it still. Mr. Bastian, Darius Whitfield said, not to Roland but to Devlin. Your name appears in this corporate registration. For the record, are you aware of Hartwell Property Services Limited? Devlin's attorney put a hand on Devlin's arm. My client will not be making statements at this time. Darius Whitfield noted it. He turned back to Priya. Margaret Chen said, I want to note for the record that my client disputes the characterization of the Hartwell entity as relevant to the company's financial. The record will reflect your position, Darius Whitfield said. His voice had not changed in temperature or tone. Please continue, Ms. Chandrasekaran. The transaction history came next. Priya had built it into a visual timeline, each of the 31 transactions, dated, sourced, and linked to the specific Bastion development property whose revenue it represented. The amounts were listed in full. The cumulative total appeared at the bottom of the last slide in the sequence. $3,840,000 diverted over 4 years and 2 months. $3,840,000. The number was larger than Priya's preliminary estimate. She had told me in December that the final analysis would likely revise upward, and it had. The room was quiet in a way that had a texture to it, not the polite quiet of people waiting their turn, but the quiet of people who have just processed a number and are measuring it against what they thought they knew. Roland said, those transactions represent authorized management fees under a consulting arrangement that Margaret Chen said, Roland. Her voice was flat and specific, the voice of an attorney telling a client to stop talking. Roland looked at her. He looked at the screen. He looked at the number. He stopped talking. The consulting arrangement, Priya said, completely without inflection, does not appear in any company documentation prior to the preparation of these materials. There is no board authorization, no shareholder notification, and no disclosure in any of the annual filings for the relevant period. She advanced to the next slide, which brings me to the securities disclosure question. This was the section I had been waiting for. Priya had told me, when she first identified it, that it was the piece that transformed the matter from a complicated family business dispute into something with no possible characterization as an internal arrangement. 2 of the 4 Bastion development properties whose revenue had been diverted had been used as collateral for a bond offering that closed in the spring of 2022. The offering documents had included financial statements for those properties. The financial statements in the offering documents reflected the reported revenues, not the actual revenues, which meant that investors in that bond offering had purchased securities on the basis of financial representations that were demonstrably false. Priya put the bond offering documents on the screen. She put the property financial statements on the screen. She put her revenue analysis on the screen beside them. The differential between the figures presented to bond investors and the actual revenues for these 2 properties, Priya said, is approximately $960,000 over the relevant reporting period. The bond offering raised $2.4 million from external investors. Theodore Ewan said out loud, "Oh God." His attorney said something quietly to him. Margaret Chen's pen had stopped moving. She was looking at the screen. Her expression was doing the very specific thing that happens to the face of an attorney when the picture they were given by their client does not match the picture on the wall in front of them. She looked at Roland once. He was looking at the screen. He did not look back at her. Darius Whitfield said quietly, Ms. Chandrasekaran, for clarity, the SEC referral includes the bond offering disclosure question. It is item 3 in the referral, Priya said. The whistleblower submission included the bond offering documentation, the property financial statements, and the revenue differential analysis. Darius Whitfield nodded once and wrote something on his pad. The whistleblower submission. Roland's voice was different now. Not loud, Roland was too controlled to get loud, but there was something in it that had not been there at the beginning of the meeting, a tightness. Who filed? He looked at Margaret Chen. Who filed the whistleblower complaint? Margaret Chen said very quietly, Roland, please be quiet. He looked at me. I looked back at him. I did not say anything. I did not need to say anything. The question had answered itself the moment Priya stood up with the 43-page report, and Roland knew it, and I let him know it without a word. His eyes stayed on mine for a moment, and then he looked away, and in that moment something happened that I had not prepared for and had not anticipated, something in his face that was not anger and was not denial and was not the controlled authority I had been managing for 3 years. It was something older and smaller than any of those things. I do not want to call it grief because I think that word gives it more dignity than it earned, but it was something adjacent to it. The face of a man who has watched a structure he built and trusted and believed was permanent begin to come apart, and who is, in that specific moment, not calculating his next move but simply experiencing the dismantling. I looked at that face for 1 second and then I looked at Priya. Continue, I said quietly. Priya advanced to the next exhibit, the Gerard Voss correspondence. She had printed selected pages, 12 of the most material emails from the 4-year exchange, which her law firm had received through the cooperation agreement and which had been formally produced to the board's outside counsel. She put them up one at a time, without commentary, reading only the sender, the date, and the relevant text. The first email was from Roland to Voss, dated 3 weeks before the first offshore transfer. It established the arrangement in language that was entirely explicit, the structure, the rationale, the distribution method, and the understanding that the transfers would not appear in company reporting. Roland had used phrases like our arrangement and the management fee structure, and when this is fully operational, neither of us will need to discuss it again. He had not used encrypted communication. He had used his company email account. Margaret Chen set her pen down. She picked it up. She set it down again. Devlin put his hand flat on the table in front of him. His attorney leaned over and said something in his ear. Devlin nodded very slowly, the nod of a person who is receiving confirmation of something they had been dreading. Darius Whitfield read each email on the screen with the specific attention of a person building a mental record. He did not speak during the email exhibit. The room was the quietest it had been. When Priya reached the 12th email, the one dated September of the previous year, sent by Roland to Voss, she read it once and advanced the slide. The text appeared on the screen in a standard email format, black text on white background, the date and sender line at the top, 12 words that had been part of my internal landscape for 2 months. The Caro woman has been asking questions. Time to close the Elliot chapter before the baby complicates things. I heard someone in the back of the room draw a breath. I think it was James Ewan's attorney. Elliot, to my left, went very still. Not the controlled stillness of someone managing their expression, the specific stillness of a person who has been struck by something that goes past strategy and analysis and documentation and lands directly in the place where you simply feel things. I did not look at him. I kept my eyes on the screen. I gave him the privacy of that moment. From across the table at the far end, Theodore Ewan said, with a quiet and very specific fury that I had not expected from a man who had been quiet for most of the meeting, "That is his daughter-in-law. She was pregnant." No one responded to that. Roland was looking at the email on the screen. He was not looking away from it. I do not know what he was thinking. I do not spend much time trying to understand what Roland was thinking in moments that were not useful to me strategically, and by this point in the meeting, the strategic phase was largely over. What remained was documentation, and Priya had the documentation. The final exhibit, Priya said, concerns the succession documents. She was careful here. This section had the most legal complexity: the performance clause, the original documentation, the amended version, the question of forgery, which had been referred separately to the State Attorney General's office. She presented the 2 documents side by side: the original inheritance agreement from the County Recorder's Office, certified copy, no performance clause. The amended version filed in September, performance clause present, inserted into a section that had previously contained different terms. The language of the inserted clause, Priya said, does not appear in any draft documentation produced by the company's estate counsel. It does not appear in any correspondence between the company and any legal advisor prior to the filing date. The formatting metadata of the amended document, which was obtained through the board's outside counsel's subpoena, indicates that the relevant section was modified 11 days before the filing date on a computer registered to, she looked at her notes, Bastion Development Corporation, specifically the Chief Operating Officer's terminal. Devlin stood up. His chair scraped back from the table loudly in a way that made 3 people flinch. His attorney said something quick and urgent. Devlin did not sit down immediately. He stood with both hands on the table, his weight on them, looking at Priya and then at me and then at his attorney, and then he sat down slowly like a structure that was losing its load-bearing capacity. His attorney said, I want to note for the record that my client disputes. Your client's denial is noted, Darius Whitfield said. His voice had for the first time a faint edge to it. Ms. Chandrasekharan, is there additional material? The report is comprehensive, Priya said. I am prepared to answer questions on any section. Darius Whitfield looked at the room. He looked at Roland's side of the table at Margaret Chen, who was making notes on her legal pad with the compressed focus of a person building a response to something that does not have a straightforward response. He looked at Devlin's attorney. He looked at the Ewan brothers' shared attorney, who had raised his hand. Theodore and James Ewan, through their counsel, the attorney said, formally request that the board impose immediate and complete suspension of all executive authority within Bastion Development, with temporary management authority vested in the board pending full resolution of the regulatory proceedings. He looked at Darius Whitfield steadily. Given what we have just heard, they do not believe a gradual approach is appropriate. Darius Whitfield looked at the two independent board members who were present. They looked at each other. One of them, a woman named Beatrice Holloway, who had been on the Bastion Development Board for 6 years and had the expression for most of this meeting of a person who was very carefully not showing how alarming she found things, leaned forward and said, "Second." "Third," said the other independent board member, a man named Carlton Park, who had not spoken since the meeting opened. "The motion is on the floor," Darius Whitfield said. "All those in favor of immediate suspension of all executive authority pending full investigation and regulatory resolution." Theodore Ewan, James Ewan, Beatrice Holloway, Carlton Park, 4 votes clearly and immediately stated. "Motion carries," Darius Whitfield said. He wrote it on his pad. "Mr. Bastion, effective immediately, your executive authority within Bastion Development is suspended. You are required to surrender all company access credentials, including digital and physical, to the board's designated representative within 48 hours. You and any affiliated parties are enjoined from conducting any transactions, transfers, or modifications of company assets or records pending resolution." He looked at Roland without any particular expression. "Do you understand?" Roland looked at Margaret Chen. Margaret Chen said in a voice that was precisely controlled and somewhat smaller than it had been at the start of the meeting, "My client acknowledges the board's action." Roland said nothing. He was looking at the table in front of him. He had been looking at the table for most of the previous 20 minutes, and the table was giving him nothing useful. "We'll take a 15-minute recess," Darius Whitfield said. The room moved, chairs shifted, people stood, attorneys moved toward their clients in clusters. Someone, I thought it was one of Darius Whitfield's associates, walked out of the room quickly with a phone to their ear. I stayed in my chair. Elliot stood. He walked around the end of the table. I watched him go. He walked toward his father, who had not moved from his seat, and he stood beside Roland's chair for a moment. Roland did not look up. Elliot said something to him, quietly. I was too far away to hear it, and I did not try to. Whatever he said, Roland did not respond with words. He put one hand on the table and pushed himself upright and walked toward the door with Margaret Chen beside him, and he did not look at anyone as he left. Devlin caught my eye as he passed. He looked at me for about 2 seconds. There was no ring turning. There was no careful performance of pleasantness. He just looked at me with an expression that was tired and resigned, and beneath that, something that was almost recognition, the look of a person who has been outmaneuvered by someone they underestimated and is arriving late at the understanding of how thoroughly. He walked out. Renata appeared at my shoulder with a hand resting briefly there, not a word, just the physical communication of a colleague confirming that we were standing where we had worked to stand. I put my hand briefly over hers, and then she stepped back. Priya was packing up her laptop with the deliberate efficiency of someone who does this regularly. She caught my eye as she closed the case and gave me a small nod, the nod of a person who has done precise work and is confident in it. Theodore Ewan stopped beside my chair on his way out. He was a 61-year-old man who had inherited a stake in a family business from his mother and had trusted it to operate honestly for 20 years without asking many questions, and the morning had clearly required a significant readjustment of something he had held as assumed. He looked at me for a moment, and then he said, "Your daughter." Her name? The question surprised me in the way that simple things sometimes arrive unexpectedly in complicated moments. "Adiz," I said. "We call her Ada." He nodded once, deliberate. "I hope she has a mother like you." He walked out. I sat with that for a moment. The January light was still doing its thing with the west windows. Darius Whitfield came back to the table with his notes and sat across from me. "For the record," he said, "the board will be issuing a formal statement tomorrow. The SEC inquiry is active. We have also been contacted by the FBI's Financial Crimes Division. I am told the case was flagged internally given the securities exposure." He looked at me with the professional attention of a man who has presided over a large number of difficult proceedings and has not often seen this particular level of preparation. "You were thorough," he said. "I had a good team," I said. "The Voss cooperation." He paused. "How did you know he would cooperate?" I thought about how to answer that. I thought about careful men who live in the Cayman Islands and keep documentation of the things other people might want to deny. I didn't know, I said, but I knew that people who have been keeping records for 4 years do it for a reason. Darius Whitfield considered that smart, he said. It came out sounding like an observation rather than a compliment, which was the form of praise I have always found most credible. Thank you for your time, I said, and I picked up my bag and I went to find Elliot. He was in the hallway near a window at the end of the corridor. He was standing with his back partly to the room, looking at something outside the parking structure mostly, which was not a beautiful view, but he was not seeing the view. He heard me come up and turned around. Hey, he said. Hey. He looked at me for a moment. His eyes were dry. He had the expression of a man who has been carrying something heavy for a long time and has just set it down and is not entirely certain yet what to do with the space where the weight was. Is it over? The meeting is over, I said. The investigation isn't. There's more to come. I know, a pause, what he said in that email. He did not finish the sentence. I know, the baby complicates things. His voice had a very specific quality on those words, not loud, not angry. Something quieter and more permanent than anger. She was already a complication to him before she was born. Yes, he looked at me. Thank you, he said, and the word carried a weight that was not about the money or the company or the board vote. It was about Ada. It was about the thing his father had written and what it meant and the fact that I had not let it stand. You don't need to thank me, I said. She's mine too. He put his arm around me. I put my head against his shoulder for a moment, just a moment, in the hallway outside a hotel conference room in Charlotte in January, with the investigation ongoing and the consequences not yet fully arrived, and my daughter waiting at home with my mother who had come up from Charleston to watch her for the day. We stood there for maybe 10 seconds, then I straightened up and said, Renata wants us in her office at 4. Okay, he said, let's go. We went. What came after the board meeting arrived in stages over the following months, the way consequences tend to when the machinery of formal accountability begins to operate. I'm going to tell you what happened to each person because I think you deserve to know how it resolved, and because incomplete endings are, in their own way, a form of dishonesty. Roland Bastian was formally charged by the Department of Justice, the SEC referral and the board's filing combined into a coordinated matter, with wire fraud, securities fraud, and conspiracy. The document fraud related to the performance clause was charged separately by the state attorney general as forgery, a felony under North Carolina statute. He entered a plea agreement in September of that year. The terms of the agreement included a substantial fine, restitution of the diverted amounts to the company, and a period of supervised release. He did not go to prison, which some people in my life have opinions about. I do not spend much time having opinions about it because prison was not the point. The point was documentation. The point was that a set of facts became a part of the permanent record. He resigned from all business activities. He and Constance sold the house in Charlotte, the one with the warm lights and the lamb at dinner, and moved to the Highlands property, which they had managed to retain. I have not spoken to Roland since the day in the hotel conference room. I do not expect to. Devlin cooperated with the investigation in exchange for reduced charges on the conspiracy counts. His cooperation was extensive enough to be material. He confirmed the complete history of the Hartwell arrangement, including his own role, which had been more limited than Roland's but was not nothing. He was fined and received probation and a permanent bar from serving as an officer or director of any public company. He moved to Atlanta. Elliot has spoken to him once since then. The conversation was civil and brief and did not produce a reconciliation, which neither of them seemed to expect. Gerard Voss paid a substantial settlement to the SEC through the cooperation agreement, the terms of which I understand included returning a significant portion of the diverted funds to Bastian Development. He remains in the Cayman Islands. His daughter's tuition, I am told, is now being paid by her mother. The Bastian Development bond offering investors were made whole through the restitution process. Theodore and James Ewan, whose stake in the company had been diluted by the same fraudulent reporting that had diluted Elliot's distributions, received a restatement of their ownership terms and a portion of the recovered funds proportional to their stake. Elliot's 22% ownership was formally restored in March, following the legal resolution of the performance clause forgery. Beatrice Holloway and Carlton Park and the newly reconstituted board offered him a board seat, which he accepted after thinking about it for 2 weeks. He is not involved in daily operations, he remains in consulting, but he takes the board responsibilities seriously, in the way he has always taken things seriously once he has decided they matter to him. The whistleblower award was finalized at $482,000, higher than the preliminary estimate, adjusted upward based on the bond offering securities findings. Renata handled the formal acceptance. I put most of it into a trust in Ada's name. Constance Bastian has called Elliot 3 times since the settlement. They have had conversations that he describes as careful. She has not asked to meet Ada. I have not asked Elliot how he feels about that. It is his to navigate, and he navigates it the way he navigates everything, with patience and a kind of dignity that I have come to understand is not passivity, but something much more deliberate. I am not a corporate attorney anymore in the traditional sense. After Ada was born, I took a consulting engagement in securities litigation that turned into a longer arrangement, and I have been doing that work for about a year now. I choose my cases. I work from the office in our house, the house with the oak tree in the backyard, which I still look at in the afternoons when the light does its particular thing. We have not moved. I did not need to go somewhere new to feel that things had changed. Things changed in place. Ada is walking now. She has opinions about shoes and strong feelings about the color orange and an expression when she is focused on something small, a button, a book, the pattern on a rug, that is so specific and particular to her that I sometimes stop whatever I am doing just to watch it. She does not know anything about what happened before she arrived. Someday she will. I have thought about how I will tell it to her, and I think I will tell it the way I have told it to you, not as a story about money or legal strategy or the mechanics of a whistleblower process, but as a story about what it means to protect something, about the difference between silence that is weakness and silence that is architecture, about the fact that some people will look at you and see a complication, and the response to that is not to make yourself smaller, but to make your documentation better. She is not a complication. She is the reason the documentation was 43 pages long. I said at the beginning that some people think I went too far. A few of them have told me so directly, members of Elliot's extended family who were not in that conference room, who know the story secondhand and have feelings about it that are shaped by how long they have known Roland and how little they want to adjust what they believed about him. I understand that. I do not require them to agree with me. What I know is this: I was a woman that a man reduced to a category, the Caro woman, and used that category as a reason to take things from my family that were not his to take. I had a choice about what to do with that. I could have accepted the fixed annual payment and the non-disclosure and the quiet erasure of what had been done. I could have decided that the cost of fighting was too high, that the disruption was too great, that protecting a smaller life was better than pursuing a larger truth. I decided differently, and I would decide the same way again. Ada, when she is old enough to understand this story, is going to know that her mother looked at an email with 12 words in it and decided that the answer to being called a complication was to build a 43-page file. She's going to know that her father sat across a kitchen table and said, "You are my family," and meant it completely. And she's going to know that people who underestimate you are giving you a gift, even if they do not know it. They are giving you the space to work in and the time to build and the remarkable advantage of being the only person in the room who understands exactly what is about to happen. My name is Vivienne Caro Bastian. I sent the SEC1 email, and if you have ever been called a complication by someone who should have called you family, I want you to know that the documentation is worth it. Every single page, hit that like button if you stayed with me all the way through, and share this story with someone who needs to hear it. Leave me a comment that says Ada below because she is the whole reason and she deserves to know how many people were listening.